All right, let's unpack this. We are diving into one of the trickier balancing acts in American criminal procedure, the constitutional requirements for criminal statutory presumptions. So basically, state legislatures, they want to make it easier for juries to find facts. They create these rules saying, look, if you prove fact A, the basic fact, you can, or sometimes must, infer fact B, like guilt, for instance. And the legal dilemma here is huge, really, because every time a state tells a jury what it should think, well, they risk stepping on the defendant's fundamental due process right, the right to be proven guilty beyond a reasonable doubt.
Yeah, and what's really interesting there is that tension you just laid out, the state's rules versus the defendant's rights. To really get a handle on this, you absolutely have to distinguish between two key types of presumptions. We've got permissive ones and mandatory ones.
Yeah.
Because the constitutional test for them, totally
Yeah.
different. And that difference decides if the inference the state wants the jury to make is actually, rational enough to pass muster.
Right. That sounds like one of those areas where a tiny technical definition ends up having massive constitutional consequences. So let's get into the doctrinal analysis. What exactly is a statutory presumption, and why does classifying it one way or the other matter so much for due process?
Well, think of a statutory presumption as a kind of procedural shortcut. It basically nudges the jury, encouraging them to find an ultimate fact, maybe illegal intent, or like in our main case, possession, just because a basic fact, like being present somewhere, has been proven. And the classification, it's critical. Because if the presumption forces the jury to accept that ultimate fact, or if it shifts the burden of proof away from the prosecution, well, that's a big problem. That violates the Fifth and 14th Amendments. So we had these two buckets. First, Rule 1, the mandatory presumption. This is the really tough one for the state. A mandatory presumption tells the jury they must accept the inferred fact unless the defendant comes up with evidence to rebut it, sometimes even if they don't. Because this basically takes the burden off the state for that element. The basic fact itself has to prove the inferred fact beyond a reasonable doubt when you look at it on its own. That standard is incredibly high, very hard to meet.
Hang on, doesn't that almost sound like it rewards clever legislative drafting? Like if the state lawyers write may infer, they get the easier test. But if they slip up and write must infer, boom, they're stuck with beyond a reasonable doubt.
That's exactly it. That single word choice, must versus may, changes everything. And that brings us straight to Rule 2, the permissive inference or presumption. With a permissive inference, the judge just tells the jury they're allowed to infer the ultimate fact. They may do it, but crucially, they are totally free to reject that inference, even if the defendant doesn't say a word in rebuttal. The burden of proof stays squarely on the state. Because of that, the constitutional bar is lower. These only need to meet the more likely than not standard. People often call this the Todt-Leary standard, named after a couple of key Supreme Court cases. The core idea is just common sense, really. Does experience tell us that the ultimate fact is more likely than not to follow from the basic fact that was proven?
Okay, so that's our framework. Mandatory presumptions face the beyond a reasonable doubt test. Permissive inferences just need more likely than not. Now, let's see how this played out in a really important case, County Court of Ulster County v. Allen. This one really cemented why those jury instructions are so critical. Let's analyze County Court of Ulster County v. Allen. First, what are the legally dispositive facts?
Okay, so the facts. You have 4 people stopped in a car. It was actually borrowed for speeding. Inside are 3 adult men, who are the respondents in this case, and also a 16-year-old girl, Jane Doe. During the stop, the police officers see 2 handguns. And these aren't small guns. They're heavy-loaded, large-caliber pistols weighing about 6 pounds together. They're spotted long crosswise in an open handbag. This bag is on the passenger side floor, or maybe the seat, right near where Jane Doe is sitting. Now, the 3 men, they get convicted based on a New York law. The law basically said that if there's a weapon in a car, it's presumed that everyone in the car illegally possesses it, unless the weapon is actually found on the person of one specific occupant.
Got it. And what was the core legal issue the court had to decide?
The central question was whether applying that New York statutory presumption, the idea that just being in the car with a gun means you possess it, was unconstitutional. Did it violate the due process rights of those 3 men?
Okay, makes sense. What rule did the court end up applying here? Did they go with beyond a reasonable doubt or more likely than not?
They went with more likely than not. And this is key. The court looked past the statute's wording itself and focused on how the trial judge actually instructed the jury. The judge told the jury they could infer possession, but he was also really careful. He reminded them about the presumption of innocence and that the state still had to prove intent and the ability to exercise control over the guns beyond a reasonable doubt. So because the judge framed it as permissive, the jury may infer, but doesn't have to admit it then. The court applied the lower, more likely than not standard.
All right, so that leads us to the court's analysis. This seems to be where the court really dug into the specifics, right? They didn't just look at the law in the abstract.
Exactly. That's the crucial move they made. They explicitly refused to judge the statute on its face. That would have meant asking if it's always rational to infer possession just from being in a car with a gun. And the answer to that is clearly no, right? Think about a taxi driver or, someone just catching a ride. So instead, the court analyzed the statute as applied just to these specific facts to this particular situation. They emphasized these weren't random people like hitchhikers or other casual passengers. And then they looked at the whole picture, the totality of the circumstances, which they felt made the inference rational here. What were the circumstances? Well, first, those guns. They were big, heavy, too large to be completely hidden in Jane Doe's purse. They were essentially in plain view, easy for everyone in the car to see and reach. Second, the court thought it was pretty unlikely that the 16-year-old girl would be the actual owner of two large, heavy handguns like that. Just didn't seem plausible. And third, the court drew a strong inference, basically concluded that when the car got pulled over, the adult men probably tried to quickly hide or get rid of their weapons by stuffing them into a nearby open bag.
So the inference wasn't just based on gun in car. It was more like 3 adult men plus 2 large visible guns plus teenage girl plus likely attempt to ditch the guns, rational to infer possession by the men.
Precisely. The court essentially treated it as if the guns were just lying out on the seat or floor, obvious to everyone. Given that specific factual picture, the court said it was entirely rational to infer that the 3 men knew about the guns and had the ability and intent to exercise dominion and control over them. Therefore, the inference met the more likely than not test in this context.
And the conclusion, what was the final outcome?
The lower court's decision, which had found the presumption unconstitutional, was reversed. The Supreme Court held that the application of New York's permissive presumption, given all those specific facts, the open bag, the large guns, the occupants, was constitutional. It passed the more likely than not test.
Okay, so Allen really turns on those specific facts, the big visible guns, the dynamics between the occupants. The court itself stressed that these weren't casual passengers. Let's flip that. Let's use the same kind of statute, but create a scenario where the inference feels completely wrong, totally irrational. Let's try one of those visceral hypotheticals you mentioned. Imagine this. You, the listener, are driving for Uber or Lyft. You pick someone up. Your passenger, without you seeing, puts a tiny little Derringer pistol. It's loaded, but it's completely wrapped up in duct tape, totally concealed deep inside the closed center console glove box. You have no idea it's there. Then you get pulled over for something minor, a broken taillight. The police search the car, find this hidden gun, and suddenly you are charged under a statute like New York's, presuming you possess the weapon just because you were present in the vehicle. Now, could a jury rationally, constitutionally, infer your illegal possession based only on your mere presence as the driver in that situation?
No, absolutely not. In that scenario, inferring your possession just from your presence, that's plainly irrational, as the courts would say. It fails the constitutional test, hands down. And this hypothetical perfectly highlights the argument the dissenters were making in Allen. Remember, New York law defined possession as having dominion or control over tangible property. Your presence as a rideshare driver, where you have zero expectation, let alone knowledge, of what passengers might secretly stash in your car. That doesn't even begin to imply you knew about or had control over some tiny, deeply hidden object like that taped-up Derringer. The inference just doesn't work. It fails the Leary-Tott standard because the ultimate fact your possession is simply not more likely than not to be true based only on the basic fact of your presence in the car. Common sense tells you that.
That really drives home how crucial the specific context is for these permissive inferences. It's not just about the statute, it's about the reality of the situation. Okay, so for our listeners, especially the learners, trying to master this tricky doctrine, how can we tie all this together? Can we synthesize these rules into a practical checklist for spotting and analyzing these issues?
Yes, definitely. We can boil this down into a clear 4-step diagnostic checklist. Think of this as your go-to framework whenever you encounter a potential statutory presumption issue, say on an exam or just analyzing a case. Step 1 is identify. Pretty straightforward. First, you just need to spot it. Is the prosecution using some kind of a statutory rule, a presumption, or an inference as a shortcut to help prove a required element of the crime, like intent, knowledge, or, as we saw, possession? Step 2 is classify. Okay, you've spotted a presumption. Now, how was it actually presented to the jury? You need to look closely at the statute's language, but even more importantly, at the judge's specific instructions. Did the judge say the jury mandatory, must accept the inference? Or was it permissive, may infer, meaning they could reject it? This is crucial. Step 3, determine the test. Your classification in Step 2 dictates the constitutional standard. If it was mandatory, the state has the highest burden. Does the basic fact prove the ultimate fact beyond a reasonable doubt? If it was permissive, the burden is lower. Is the ultimate fact more likely than not to flow from the basic fact? That's the Todd-Leary test. Step 4, contextualize. This is the critical Allen step, especially for permissive inferences. You can't just look at the presumption in a vacuum. You must evaluate the totality of the circumstances as applied to this specific defendant. Consider everything: the nature of the item, size, visibility, the relationship between the people involved, the likelihood of awareness and control based on the situation. Does all that context make the inference of guilt rational? Does it make it more likely than not true for this defendant? If the inference feels irrational given the specific facts, like our Uber driver hypo, then it fails constitutionally, even if it's just permissive.
That framework really lays it out clearly. Identify, classify, test, contextualize. Excellent. This deep dive really underscores how much can hinge on subtle differences in legal language that shift between may infer and must accept. It dictates whether the state needs to meet that incredibly high, beyond a reasonable doubt standard for the presumption itself, or just the lower, more likely than not bar. But let's circle back for a final thought, touching on that concern from the Allen dissent. If the court, when evaluating a permissive inference, gets to look at all the evidence presented at trial, not just the basic fact that triggered the presumption to decide if the inference was okay, well, does that create a risk? Could it let states get away with using presumptions that are, on their own, pretty weak or even irrational, simply because the rest of the evidence against the defendant happened to be strong? If the final check is just, was the conviction supported by the whole record, quote, does that undercut the specific protection against irrational presumptions? That's definitely something worth mulling over.